That's right. People waiting to know the fate of the BBI, or as it's called, reggae, and the 7-judge bench will decide on this in the next 1 hour or so. The Supreme Court ruling will begin, and that is the final. The 7 issues that they're going to talk about. One of them is whether the BBI process was legal and if the 2010 constitution can be amended or it's immutable. Number 2 is if president participation rendered review push illegal and if he enjoys immunity from prosecution. There are 7 issues that they're going to talk about. But let me start with you on this, Mutuma. What are the possible outcomes and what is the impact on the elections, knowing that it's just about 130 days with the polls?
Thank you, Trevor. First, let me begin by saying that the reason why Supreme Courts are established all over the world, number 1 is to develop the law, to expand jurisprudence, and to settle legal quagmires. So we expect our Supreme Court will do exactly that, not necessarily in terms of making, a final determination on the BBI issue, but address those 3 issues, because the Supreme Court then is the highest court in the land, and its decision is very important and will be used by the courts below it and even across the world. The possible scenarios is that, like you've said, we have 3 main issues for determination. 1 is the question of the presidential immunity. The other is the question of the applicability of the basic structure. And the other issue is whether the president can initiate a popular initiative in a manner that he did to amend the constitution. So the possible scenarios is that 1, the Supreme Court will uphold the decision of the Court of Appeal, effectively rendering BBI pronouncing a death on it with finality. The other possible scenario is that the Supreme Court might want to water down some of the tight nuts that the Court of Appeal put in terms of amending the Constitution to allow amendment of the Constitution through a parliamentary initiative. Remember, as we speak today, if the Court of Appeal's judgment remains, not even a parliamentary initiative would easily pass as a way of amending the Constitution because of entrenching of the basic structure in our Constitution. The other scenario, of course, would be to allow the appeal, effectively reviving BBI and allowing the process to continue. As to whether that is possible to be done before we go for elections, it's another discussion, but those are the 3 scenarios.
Prof, what happens when they uphold some and overturn some?
Trevor, at the very foundation, and I say the prolegomena in this disputation is the basic structure. The basic structure doctrine sets off everything and would define whether or not reggae can be back to its feet in another form. So that if you find then that you can amend the Constitution in the manner contemplated by Article 257 and in the manner that the amendment was commenced by His Excellency the President through the committee that was appointed, it means that then you can get certain things right, even if the court finds that certain other things, including, because questions like the culpability or non-culpability of the president are side questions. Whether he can be taken to court for violations, those are side questions. Those do not go into the depth of the process of constitutional reform. Now remember, this basic structure doctrine, if the court locks the door on the basic structure doctrine, then it means that we will continue to have a rigid constitution that will be incapable of amendment in the form proposed in the BBI draft. So that is important. Secondly, on the question of IEBC, the question of whether or not, and I told you I litigated the 2 cases as IEBC advocate, and I won the cases as to whether under the IEBC Act, 3 is a quorum. That was a finding by the High Court, and then, of course, this BBI thing then came and found the opposite. That is important for a clean conduct of the elections, that it then also sanitizes whatever the IEBC did before the other commissioners came on board. That is an important process because it also goes to the rules. On the question of validation of the register for the referendum and the existence of a law, a referendum act, I think that will give Parliament an opportunity to deal with the gaps that are there. And that can be done even when reggae is back once the basic structure is unlocked.
Yeah.
And this amendment then can move forward. I think question of signatures can all be regularized. So I think for me, the biggest win in the BBI debate or in the reggae debate is this, that if the court largely finds that this process can get back on whichever form, then it is a win for Azimio, because then it can provide a formula for sharing of government and provide hope for members of coalitions that are there. And this is both to Azimio and to Kenya Kwanza anyway, that it gives you a framework to form a workable structure of an executive. I think that for me is the biggest win for unlocking the BBI today by the Supreme Court. And my guess perhaps is correct, that there will be certain wins in the Supreme Court. The Supreme Court will overturn a number of findings of the Court of Appeal, including the basic structure doctrine.
Mutuma, is that your reading as well? This is a legal battle, so I'll come to this side in just a bit. But do you agree with what Professor is saying?
To some extent, I do, because like I said, that this appeal will turn on the basic structure issue, because it's so basic and fundamental in the amendment of the Constitution. Because as we speak, if the judgment of the Court of Appeal remains, then it means that we'll have to find another way of amending our Constitution, not relying on Article 255, 256, and 257. So I believe the Supreme Court might want to readjust some of the, tight holdings that were put in by the Court of Appeal to allow a different way of amending the Constitution without really being very strict on the basic structure doctrine. So they might hold that the basic structure applies, but as to how it applies is a question they might want to expand on.
Prof, should they uphold the basic structure doctrine, what then will that mean for amending the Constitution?
The door will be locked. The door will be locked. It would mean that then for any, and Parliament would then have to go back and fall back to Article 256, the parliamentary initiative, which was always open to Matangi and his colleagues. They would then frame questions, specific issue amendments, because that is another question that I want to see how the Supreme Court decides. Whether you can limit questions on or issues for amendment, define those issues, and not bring blanket amendments on touching on all areas. If the Supreme Court finds that the basic structure doctrine must strictly be applied, it means that certain blocks of the Constitution or certain chapters would then be immutable. It would mean that, and hyperbolically speaking, it would mean that you cannot then change a framework. The Constitution is a basic document that defines the structure of government and that captures the ethos of a people. Those are variables that change over the years. You cannot say that a constitution cannot be amended. And that is the problem here, that the Supreme Court has the pain or the duty of balancing interests. And I don't think the Supreme Court would say that the Constitution of Kenya 2010 is a fait accompli, and that it cannot be amended. It is the end of the road for Kenyans. No, it will not say that.
Okay. All right. Let me bring in Mutu on this. Yes.
I think the most important thing that I'm taking from all this debate is our democracy. That we're in a country that follows due process. That somebody can go to court and challenge even a decision by the president. And it goes to the court, it goes to the Court of Appeal, it even goes to the Supreme Court, and Kenyans will accept the verdict of the Supreme Court. It shows our democracy, that we're a stable country. We're a country with a country of law and order. It's very, very good. Now, this issue also that senior counsel has talked about, Mutuma has talked about, and that is, a constitution is a guideline. It is not set in stone. and it changes with community values all the time. All constitutions do. If you look at the American Constitution, for example, which I studied when I studied in the US, you find that they have had amendments. As you talk about things that were not there in the original Constitution, like the First Amendment. It's called the First Amendment, of freedom of expression because it is an amendment. Second Amendment, the right to bear arms, it's an amendment. Fifth Amendment, the right not to self-incriminate, it's an amendment. 13th Amendment, amendments were done even to include to have people who are not allowed to vote, like women and minorities, vote. These are amendments. So a constitution has to be amendable. And I believe, from where I sit, knowing that the Supreme Court judges also do not live, in a cocoon box. They live in a society, and they know that things have to progress, that they are going to rule in a way that is going to make it easier for us to amend the Constitution, not only this time, but even tomorrow and in days to come, for the benefit of our people. You see, Kenyans have always wanted change, and you cannot stop Kenyans from wanting change. That's why we want the new Constitution. And we want change that actually improves quality of life, enables us to move forward and add more money into our pockets, and enable us to enjoy the democracy that we're enjoying today. I have a question, even before my colleague here, I have a question for the legal team, for the legal side. Is there any decision that can be made by the Supreme Court today that would affect the forthcoming elections and the date of the elections of August the 9th? Is there anything they would say that would push back the election time? I'm just wondering, is there anything that can be done that will change the politics as we see it in this country today? Or it's just this is neither here nor there? Or second question is there anything that they will do or they can say that will lead to Parliament making decisions even before the elections, or everything has to be done after the elections?
All right.
Or maybe
then we can also pose your question to the legal team because they're here.
Or maybe to reframe that question, maybe what I see Dr. Mutua attempting to ask is supposing, or would there be a possibility that in the event that the Supreme Court would unlock the process, would there be a possibility that within this time before the elections, that there are certain things that would be done that would probably affect the process of elections, because we know that in the BBI there were provisions that would have definitely altered the way in which we do elections today. Supposing then the Supreme Court made decisions that would open the gates, that indeed this process was legal, it could have gone on the way it had started. Are there certain things that the players would do, and maybe even including the legislature, that would force a rethink of the elections? For example, the provisions of which positions are can be allocated or earned by individuals by virtue of maybe the political parties, numbers in the House and so on. So they have prime ministers and so on and deputies. Would then that affect the timelines? I think I get that to be what he's asking. It would be a good question to answer. But then let me also bring in something that I was thinking along, that I believe our legal side there can answer. And let me also say that I'm happy to have that legal side the way they are formed, because if this presidential side were to win the elections and we became president, then you know...
We know where to get our legal advice.
We know where to... it could be a good start.
Okay.
But anyway, when Wakili Mutuma was speaking, and then he was explaining the purpose of having a Supreme Court, and indeed the role of the Supreme Court, and especially in expansion of jurisprudence. And probably one question that would come to a layman's mind, because we are being watched by everybody, is in the concept of development of jurisprudence, is there any time when it is envisaged that we would get to the promised land? I mean, promised land meaning that you would not have business, that you would not have overactivity of new things coming up that would require Supreme Court to go and jog its mind over this or that about a constitution. Is it envisaged that within 200 years of our constitution, like in the USA, that you would get to safe, calm waters, whereby we have done this so many times that you have now a constitution that can flow for a long time without, requiring those amendments? I think that's one question that one would ask. But let me then make this final comment, which I think you would also comment on, is then based on that thought line, that indeed the existence of the Supreme Court is premised on the need to continue to develop, expand, and grow jurisprudence, then how is it then that a court within the judicial system would be making a judgment to suggest or to propose that the Constitution is immutable? Because it then contradicts totally. Probably just for the understanding of viewers, when we speak about the Constitution being immutable, based on that basic doctrine, it is important for our viewers to understand that when you say immutable, you mean that it is unchangeable.
Yeah.
And so, based on that argument, is it fathomable then that one court would be saying that the law is immutable as it exists within our supreme law, and then you have in existence within the same line of judicial processes a court that is intended to continue to grow that jurisprudence? That means that you expect just by that formation that law has got to continue to develop and change over time. And I believe that was the wisdom in the first place. Even when the founding fathers of the United States Constitution, when they sat and they saw the need to include the provision of amendments of the Constitution, it is to accommodate the reality that constitutions have got to accommodate the changing times and tunes in the development of a human society and community.
Okay.
That was my thinking.
Prof, I'll start with you on the reactions. Is there anything that the Supreme Court can do that will then alter the elections date?
let me put this within a framework. And let me, first of all, deal with the question, the big elephant in the room, the jurisdiction of the Supreme Court, which is found under Article 263 and Article 163, 4A, A and B. Now, A is matters of application and interpretation of the Constitution, and that is where you also find jurisdiction in normative derivatives of the Constitution. Then you have the public interest jurisdiction, where on any matter of public interest, you have the Supreme Court can exercise it. You remember, the Supreme Court is the apex, is the highest court of the land, and that is why it will hear petitions from the presidential elections and matters of the Constitution. So, and I agree with you, that for the Supreme Court to find or to vouch for the immutability of the Constitution would be to miss it by many miles and to tell Kenyans that you're transfixed in a legal space that you cannot change. Now that is unthinkable, I must say, and I agree with you. And that is why Advocate Mutuma said that the basic structure doctrine will define, and the Supreme Court must be alive, will make a finding on the basic structure to unlock this process so that, we are able to move as a country. That's number one. Number two, changing an election date is impossible under the law unless there's a war. And you can only postpone elections for 6 months and so on and so forth. So that is unthinkable because we are there. So the 9th August is fixed by the Constitution. Second Tuesday of the month in August, 9th August, is fixed by the Constitution. That cannot change. In terms of legislation, I know the amendments, for instance, the Elections Bill 2021, I think is before Parliament. There are things that can be amended to impact on the election, but that is through amendments to legislation, not the Constitution. The framework for amendment under Article 255, 256, and 257 that we have referred to, Parliamentary Rule 256, Public Initiative 257, which is under consideration by the Supreme Court, are complex and must follow the four-stage process. Yeah. And that four-stage process takes time. It is almost impossible to recommence the constitutional amendment process, even if reggae rose back to life as it shall before the election. That's a process that will give hope that will only be commenced after the election.
But Wakili, maybe if I could just ask a question that you can marry with that. You know, the court has previously ruled on the tenure of office for members of county assembly.
Yes.
When that matter came in court. And because members of county assembly are elected representatives, giving a judgment on the tenure of an MCA would be tantamount or is tantamount to amending an election date. Because, you know, in my thinking, if the challenge in court was when does the term of an MCA end, and the court determines that indeed, as interpreted now, is wrong, that the term of office for an MCA ends at this particular time. That was given in a judgment. If somebody went to court today, that would be my question, and give reasons and arguments before a court of law based on what has happened, and maybe if reggae came back to life, wouldn't that be probably also a window within which considerations by the court would render a date being changed in the event that they find that there are certain issues? I mean, the Supreme Court has, in its time, also annulled a presidential election and ordered for another election that was not provided for in our Constitution. So, supposing then that happened, they could change an election date. What we're just trying to find out, Wakili, what we're just trying to find out is that because you are a good man in law, that you will also not going to be going to court to change the law.
No. It would be hard. Yeah. They can't, because the election date is transfixed, that cannot be tampered with. The MCAs, acting through the CAF, because CAF is my client. Yes. Went to the Supreme Court, to the High Court and Supreme Court because of the term, the time they took office. So they were seeking to kind of extend time to be paid because they came into office late because of the times it took time to put into frame the initial nominations and processes that made assemblies function then. So they were just coming to court to say that they should have been, they should be paid up to December of the year that they served. I think that probably would be a distinct case that even when the Supreme Court renders its finding, it would have to note that that cannot apply in other situations, because in every year after the first term, after the adoption of the Constitution of Kenya 2010, we have had predictable elections, and that will not change. So I don't think there's a problem there. Yeah. Trevor, my concern is, I am sure that the Supreme Court also reads what is on the ground, like Governor Mutua says. They also know what is on the ground. They are not insensitive to the wishes of the ordinary Kenyan and the thinking of the ordinary Kenyan on questions that touch on the lives of the ordinary Kenyan. They also know that the constitutions must change. And that is why I expect a verdict that will, in some measure, be different from what the Court of Appeal. So
does the Supreme Court, Mutuma, base its arguments and decisions on the law or popular opinion?
On the law,
well, of course, they are not supposed to be influenced by anything said outside there, because they are supposed to render the decision in an independent manner. That means free from any sentiments that are out there. But just to answer the question by Governor Mutua and Senator Omatangi, I participated in the BBI cases right from the High Court. My petition is one of those that won from the High Court all through to the Supreme Court. The issue of whether this judgment we're waiting for as the ability to alter the election date is not a possibility at all. Okay. For the simple reason that that has not been an issue that has been determined either by the High Court, Court of Appeal, or even the Supreme Court. None of the parties has litigated upon that issue, so the court cannot render a decision on a matter that has not been presented before it. Second, even if Reggae was to be revived, it would not affect the 2022 August general election for the simple reason that an election is a process which has already begun, right from when IBC gazetted the election date. Remember, the election date is cast on stone by the Constitution. No one can ever tamper with that. So if then we were to amend the Constitution now and want to apply it to this general election, it would mean we are applying the law retrospectively, going backwards, which is not allowed under the law, because it would mean that we have to go back and start redoing what has already been done in terms of preparation of the general election. So there is no possibility at all that we could have an amendment to the Constitution that will affect the forthcoming general election. On the other issue as to whether we will reach a point where we will have solved all our legal issues and the Supreme Court will even have no business anymore, I don't think there's that possibility, because the law and the Constitution is supposed to meet societal expectations and needs, and they are not static. They keep on mutating and revolving. So unless you tell us that we no longer have concerns that are emerging, then we will always have the Supreme Court and the other courts having that opportunity to address emerging issues and develop the law to just be able to address societal needs.
Wakili, if somebody went to court with a petition citing reasons to change the election date, maybe when Reggae has resumed, would the court entertain that kind of petition?
Well, the court will entertain the petition because they are bound to hear any party that comes before it. But as to whether they will allow it is a different issue. The court has said not once, not twice, that constitutional timelines and constitutional dates are cast on stone. A good point is where Honorable Martha Karua tried to have a petition in respect of an election dispute had beyond the time limits, and the court was very clear that your right has been violated, but then we are sorry, we cannot hear your petition beyond the constitution timelines. So there is no way that any court will hold that we can have an election beyond 9th of August 2022.
This is the legal side, this is the ground side. Now let's ask the ground question. So was the BBI a good idea based as a governor? Was it a good idea?
For me, the BBA arose from the feeling that the winner-take-it-all scenario is bad for this country. And that's where we are again. People are talking about two horses. If you look at the newspapers today, it's the uppercut, it's all these things. It's this person against this person. It's about broadening the base such that there are more players involved. So it's not just about kufa na kupona. That's the premise of BBI. I think the mistake that happened in the BBI eventually, and that is that too many other things were added. It should have just been very simple in terms of what do you want to achieve. We want to achieve a stable country where the economy can be able to grow with political stability. And in that way, it was a good thing. It was a good thing. If I can give my closing remarks at this time also, say that, we're going to watch this judgment. I'll watch it. I want to watch all of it and listen. And because it has a lot of... it will set the guidelines of how we are going to operate in the future and how, as a country, we can lift ourselves from where we are in the future. Some people will take it as a win on one side or a lose on the other side. I think it should be concentrated on the person to win or lose is a Kenyan. It's not a certain politician or other politicians. And lastly, I'm still very worried about this impeachment business, because I went through the same problem in Machakos. I had my deputy governor then, called Kiala. I got together with Kalonzo Musyoka and others, and they said, let's find a way of removing Mutua so that you can be the governor. And they try. It's not based on anything wrong you've done. It's about greed and quest for power. They failed, because, we are also not as stupid as we may look. We're also smart in some ways. And they failed, completely failing. And, but then it renders, it's a very big question. If it is true, and I think it is true because Junet, who has taken the Quran and sworn to uphold the truth as a public figure, cannot hold up an interview and say, I was in a meeting with Ruto where he was urging us to join hands and impeach President Uhuru Kenyatta. And when Junet speaks, it is Raila who is speaking. So basically, it's Raila saying, I was approached by Ruto, say this. It's the same way when you hear Sudi speaking or Murkomen speaking, that's Ruto who is speaking. We know that Junet is speaking, it's Raila speaking, saying, I was basically approached by Ruto to impeach President Uhuru Kenyatta. Okay. If that isn't true, and I think it is, then that renders Ruto to be a very greedy person. Okay. And to lack of any word, that is evil. Okay. I mean, you don't do that. There's some things you don't do. Okay. So that comes down to the question of how watu walifanyana nini? Ni nini Uhuru aliona akasema huyu hatoshi, and my friend here, I fear for you. Right. Because if somebody can join hands to try and impeach the president, and they are working in the same team from within the same party, it's not even from, you'd expect ODM to be pulling numbers to impeach Uhuru from Jubilee. But this is Jubilee from within trying to impeach the leader of the party from within and joining hands with the enemy to do it, and you've just joined that team. My friend, be careful.
Okay. Before I come to you to make closing remarks, Imani Wamatangi, let's make an establishment of where we are right now. Supreme Court, you can see the live pictures coming from there. The 7-judge bench is expected to walk in at any time from now. They're supposed to start at 9 a.m. in the next 30 minutes or so. We have wall-to-wall coverage for you at the live of the Supreme Court. You can see the live pictures there. We also have John Wanyama standing by in Eldoret. He'll be giving us reactions from the people on the ground. We keep saying that it's a ground in the legal battle. We also have Laura Otieno standing by in Kisumu, and Martin Munene is in Nyeri. At the Supreme Court, we have Francis Gashuri and Sam Ogina, so you can be assured that we'll be giving you wall-to-wall coverage of the entire Supreme decision as soon as it kicks in from 9 a.m. All the judges are going to read their verdicts on all the 7 issues that have been raised one at a time. And that is also the other question that I want to bring into my guest also with the legal team when we get to you in just a bit. But first, let me hear from Wamatangi in the closing remarks. Yep. And then the legal team can tell us by the time the 4th judge speaks, shouldn't we have already known where that is heading? Because if they're going to give direction on each and every one, then we know. Right? But
yes, Trevor, just the 2 issues that have arisen. First, you asked, was the BBI a good idea? Yeah. And I think it was a good idea in the first place. Because there are very good provisions that were contained in the BBI that people would associate themselves with and find that they are life-changing issues. Remember that process was owned by the people in many ways. But then along the way, the process was hijacked. It was modified. It started to be tailor-made for certain reasons. And that is where people lost touch with the BBI. And that is why you find that then the confidence that the people had in the BBI came to question. And people pulled back. And the court also took it up and took issues with it. And I pray that the judgment that's going to be given by the Supreme Court be a judgment that will allow Kenyans to involve themselves with this process, whichever decision they make, but let the country remain united as it is. I hope that if, for any one reason, that this process was to come back to life, that the ones who propagate it, the ones who started it, the ones who want to continue with it would know that it can only be and should be for the interest of the people. But the question that will be alive after this judgment, and I believe that's what we try to tackle when we're having the first debate, is the timing. The timing. And that's why you found I was asking those pertinent questions to the legal side. Finding out that if we have then this process up at a time when we are facing elections, what are the possibilities? That's why you had me ask all those questions. Mm-hmm. Because we do not want to have a process or a judgment that is going to be so mistimed that it will trigger individuals who may have other selfish interests to hijack this process, start playing reggae around the country, saying things, and forming caucuses, making declarations, alignments that are going to take this country in the wrong direction when we have an election around the corner. Because then what will be happening, Trevor, is that we'll be watering the shed for our own Waterloo, where we are going to not only have grounds for rejecting an election and the outcome, but we would also have imposters trying to claim certain victories or positions because of that judgment. Now, lastly, my running mate says that he fears for me because of of where I am, and you know, I'm taken very good care of because we live in the same country with you and with everybody, and we have laws. That is why you find we are patiently waiting for the BBA verdict. We have a framework that protects everyone in whichever way, and for me to have made that decision, my running mate, I had made several considerations. Remember how consternated we were ourselves when me and Trevor waiting for you to come from the US and arrive here, and we hold hands and launch our campaign as co-principals in an election where you are going to be president and I was going to be your running mate after an agreement. Then we saw him in a rally in Makueni, and it was Trevor who was exclaiming, "Oh my goodness, what has happened to your running mate?" Because we are waiting for the launch date, and there is your running mate endorsing another candidate. So probably, you know, that same consternation is the same we had. But then to my closing remark.
Very briefly.
Very briefly.
Yeah, because I need to do this.
Because, Trevor, let me make this a bit personal, because personal in this sense, that I want to entrench, highlight the idea that where we are as a country right now, the last thing we would expect, and we expect onwards when we are campaigning, is violence within political campaigns in the country, because that is what has brought this country down to its knees. And I want to say to all the people, and especially from where I am within my county of Kiambu, I want to let the people know that the party that we have formed and the principles that we uphold are intended to make the lives of our people better. And the last thing that we are going to entertain is violence, and especially sponsored violence, whereby people will be trying to make events of the UDA party look like they are violence-ridden. And that is not limited to only the system. It is also extended to people who may be sponsored by the system and by other people to come and spoil events so that it looks like the party is a party of violence. We are going to proceed and have nominations. We'll have candidates in a peaceful process, and we will have competitors who will take those positions to lead this country to prosperity.
Mutuma, very brief closing remarks. I need to go cross over to the Supreme Court.
Thank you. First of all, let me wish well Prof. Tom and Senator Omatangi well in the nominations. And I say that because with the coming into force of the Political Parties Amendment Act, nominations become a key issue in this election. Most of the aspirants will either lose or win at the nomination level. I know, especially when the deadline for submission of party list was on 26th of March. After that date, it means that you are stuck with your party. So you win or you lose, then it's a done deal for you. So I wish them well, and I hope that to see them in Parliament next year.
All right, Prof.
Thank you, Mutuma. We will be in Parliament.
Thank you.
And I can assure you that we'll then engage at that level. Now, just by way of closing, let me reiterate the remarks by Senator Wamatangi on the need to keep peace during nominations and during the election, and to ensure that the outcome of the BBI judgment does not evoke emotions in any manner. I believe that, Wamatangi, I hope that your party, the UDA, will conduct credible nominations in the same manner as my party. You know, my party has embraced a three-tier approach: consensus, the best candidate from the opinion polls, and then nominations, the vote. And I think that it is clear that for those of us who are ahead in those polls, we are not worried. I hope you are ahead.
All right.
The point I was alluding to, and I agree with you entirely. You know, in UDA we have a different problem, or rather a slightly unique problem, because we are fighting for not only survival but for entrenchment, to ensure that there is a very well choreographed arrangement, whereby you find in some cases deep state, in its own definition, has found means to sponsor some candidates even within the party, so that they can be agents who look like they're competing honestly within our party. And when they look like they're competing honestly, their intention is to, when prompted, to cause violence, to give the party a bad name, and probably even if they win onwards, to go and sell out the party victory. And that is what we'll be looking out for, and that's why we are saying that we have to be vigilant, and we are vigilant, and we are a party that is going to win the positions that we're fighting for, and will show the world and show the country that we have what it takes to lead this country.
We have to leave it there. Dr. Kimani Wamatangi, Senator Kiambu, thank you so much for making time. Professor Tom Ojienda, Senior Counsel and Kisumu Senate Aspirant, asante for making time. Dr. Alfred Mutua, Governor